Good morning, everyone, and welcome to the Arthur V. Mauro Institute for Peace and Justice at St. Paul College at the University of Manitoba. On behalf of the interim director of the Mauro Institute, Dr. Sana Lutfilla, who is traveling internationally at this time, my name is Omar Tejada, a student of the master's degree program in Peace and Conflict Studies, and I welcome you to today's lecture. The University of Manitoba campuses are located on original lands of Anishinaabe, Creek, Oji Creek, Dakota, and Dini peoples, and on the homeland of the Métis Nation. We respect the treaties that were made on these territories. We acknowledge the harms and mistakes of the past, and we dedicate ourselves to move forward in partnership with the indigenous communities in a spirit of reconciliation and collaboration. Today's lecture is taking place both in person and online, and the lecture is being recorded for future broadcasts on the Mauro Institute YouTube channel. The lecture will include a 30 to 35-minute presentation followed by a question and answer session. Online viewers are asked to type their questions in the Q&A box on the Zoom platform. Our lecturer today is Dr. Nathan Derejko. Dr. Nathan Derejko serves as the Mauro Chair in Human Rights and Social Justice and Assistant Professor of Law at Robson Hall here at the University of Manitoba. Our founder and principal benefactor, Dr. Arthur Mauro, was a graduate of both St. Paul's College and the University of Manitoba's Faculty of Law. The Mauro Institute and Dr. Derejko, as Mauro Chair in Human Rights, thus share the honor of carrying this name forward in pursuit of truth and justice. Previously, Nathan was the Director of Human Rights Center Clinic at the University of Essex, Director of the Masters in Human Rights Program at the University College London, a visiting lecturer at the International Institute of International Humanitarian Law in San Remo, Italy, and a doctoral research fellow at the Irish Centre for Human Rights at the National University in Ireland, Galway. Nathan's research and teaching interests span three interrelated fields of international law: international human rights law, international humanitarian law, and collective security and the use of force. Nathan's research has been widely cited both within and beyond academia, including by the United Nations Development Program, the International Committee of the Red Cross, the New York City Bar Association. Nathan has a PhD in international human rights and humanitarian law from the University of Essex in the United Kingdom, and LLM in international human rights law for the National University of Ireland, Galway, and a bachelor degree in political science from Dalhousie University in Canada. Today, we are pleased to welcome Dr. Nathan Derejko to the Brown Bog Lecture Podium. Please, Nathan.
Thank you, everybody, for coming, and hello to everybody online. I'll probably just focus my attention on the people that are physically present, so I'm not ignoring, or I'm not even sure where to look where the camera is. Oh, it's right there. Perfect. Okay. All right, so thank you for coming. Today we're going to kind of unpack and critically examine one of the most complex and controversial issues currently at the forefront of international law and international debate within the United Nations. And that's the question of whether, and if so, under what conditions, peacekeeping forces should actually be considered as a party to an armed conflict. Okay? And so this spans many issues. We're going to approach this question from the perspective of international law. So we're going to touch on 5 things today. First, I'm going to just provide some background information very quickly on 4 relevant bodies of law that I'm going to be citing constantly throughout the presentation. Then I'm going to kind of set the stage of this dilemma that I'm calling it a dilemma that we're in, whether peacekeepers or are they parties to an armed conflict and what's that difference. Then we're going to briefly look at the difference between peacekeeping and so-called robust peacekeeping. And then we're going to look at three different positions. One, we'll look at the United Nations position. Then we'll look at the legal position from the perspective of the Security Council mandates. Three, we'll look at it from the perspective of international humanitarian law. And then finally, we're going to wrap up. I wanted to highlight three implications if we decided that, yes, peacekeepers are a party to the armed conflict. I just wanted to highlight a few legal and practical implications that would emerge from this determination. So in terms of four bodies of law, first is what we call the jus ad bellum, and this is just a Latin term for the law regulating the use of force between states. It's primarily found in the UN Charter today, and for the purposes of today's lecture, all we have to know is that with the Security Council, when it's acting under Chapter 7 of the UN Charter, it has the ability to create binding international law on everyone. So when it passes a Chapter 7 resolution, it's creating legal obligations for the entire community no matter what. Okay, and that's the legislative competence of the Security Council. There's no institutional check on it, and there's very few limits that can be imposed upon it. The second body is called the jus in bello, and this is Latin for the body of law that regulates the conduct and consequences during armed conflict, also known as the law of war, the law of armed conflict, or more recently, international humanitarian law. There's a few things that I need to state. First is that international humanitarian law only applies when there's an armed conflict. If there's no armed conflict, this body of law simply doesn't apply. Second, there's two types of armed conflict. An international armed conflict, which is an armed conflict between two states, and then a non-international armed conflict, which is basically the legal term for civil war. So it can be between a state and an armed group, or between two or more armed groups absent the involvement of the territorial state. International humanitarian law, unlike human rights law, binds both parties, binds everyone. So it binds rebel groups, it binds corporations, it binds everyone who's a party to the armed conflict. And that's really important. And finally, the jus in bellum and the jus ad bellum are completely separate bodies of law. So factors happening at the jus ad bellum, at the UN level, don't influence the applicability of international humanitarian law. And if we use the situation in Ukraine right now, no matter what the legality of the war was, all parties to the armed conflict in Ukraine are bound by the same rules equally. It's called the equality of belligerents. Then there's international human rights law. For our purposes today, we'll just know that it's the default legal regime that applies everywhere at all times. Unfortunately, technically speaking, it only binds states right now. That's something beyond the scope of today's lecture, but it's important to keep in mind because the question of whether peacekeeping forces have human rights obligations is also at the forefront of international debate, but definitely beyond today's presentation. And then there's international criminal law, and this is the Rome Statute of the International Criminal Court. The one thing I want to highlight, which is of most relevant today, is from international humanitarian law, and this is the principle of distinction. And it's twofold, persons and objects. The parties to an armed conflict must distinguish between civilians and combatants and only direct their operations against combatants. And the parties to an armed conflict must distinguish between civilian objects and military objectives and only direct their military operations towards military objectives. That's the golden rule of international humanitarian law, rule number one. So with that kind of abridged version of introduction to international law, we will continue to this current dilemma. Increasingly, we're seeing that the UN Security Council is dispatching peacekeepers to situations or to countries where there's literally no peace to keep, but rather a battered government embroiled in a non-international armed conflict with one or even multiple armed groups on its territory. And this is creating operational challenges for these troops on the ground because they're not there to monitor a ceasefire agreement, or they're not there to monitor a border dispute or provide protection during elections, but they're being confronted by heavily armed and sophisticatedly organized armed groups that are engaged in an armed conflict with the territorial government. Now, in response, the Security Council is creating these new mandates for a few of its peacekeeping operations. And we call them robust mandates, and we'll come to that in what that really means in a little bit. But basically, it's at this point where they're beginning to diverge or go into activities that they've never gone into before in terms of directly confronting one of the parties to an armed conflict or launching military operations. And basically, we're at this point where there's a question on whether these robust peacekeeping missions are actually compatible with the three fundamental principles of peacekeeping that have underpinned and informed the entire history of peacekeeping in international law. So what we're seeing as a result is we're seeing that peacekeepers are constantly becoming under attack now, and there's a significant increase in the number of peacekeepers killed in specific peacekeeping missions. Now, at the same time, we're seeing the United Nations condemn these attacks on peacekeepers at the international level, going as far as to say that they are actually violations of international law, and they actually, in some cases, explicitly state that this would constitute a war crime. Okay? And we see this happening across the board, and not just the UN, but also other international bodies, and in particular also the troop contributing countries, and that's the states who contribute these troops to these types of missions. So we have this widespread condemnation, but the dilemma is that yes, it is international criminal law makes it a war crime to target peacekeepers and target peacekeeper installations. But there's a caveat that's never quoted in the headlines, and that's not brought up in the condemnations at the international level. And it's explicit in the law. It says it's prohibited, or intentionally directing attacks against peacekeepers is a war crime if they are entitled to the protection given to civilians or civilian objects under the law of international humanitarian law. So the whole question of today's lecture is, what is the legal status of peacekeepers under international humanitarian law? Because this whole dilemma hinges on the interpretation of whether they have civilian status. And so that's what we're going to look at today. So the first thing we want to do is, well, what is peacekeeping? Because we don't see this term even in the UN Charter or anywhere, right? So basically, this idea of peacekeeping is one of a range of activities undertaken by the UN to maintain what it calls international peace and security. We have conflict prevention, peacemaking, peace enforcement, and peace building. Now, for the purposes of today's lecture, I want to make one distinction, and that's between peace enforcement and peacekeeping. Peace enforcement is when the UN Security Council identifies a threat or a breach to international peace and security, and acting under Chapter 7 of the United Nations Charter authorizes a state or a coalition of states or an international organization such as NATO to intervene militarily in the territory of another state. Usually, this would be a violation of international law, but because the Security Council has authorized it under Chapter 7, it's no longer a violation of law. The most recent example of this is Libya 2011, when NATO intervenes. That was under the legal mandate of the United Nations Security Council. Today, all the peacekeeping operations we're talking about are with the host, the territorial state's consent. The territorial state has consented to it. So the boundaries between this idea of conflict prevention, peace building, peacemaking, peacekeeping are becoming increasingly blurred, right? And these types of activities rarely happen in a linear or sequential way, but they overlap and intersect. And this is now becoming by design. As the history of peacekeeping evolves, we see that there's a whole movement to integrate missions to take a holistic approach to peace. So combining all these different elements of peacemaking into one and calling it this multidimensional operation or integrated operation or stabilization, multidimensional integrated interim operation. And these has legal implications that we'll talk about a bit later. So there's 12 peace operations in the world today listed on the side. And all of those peace operations are governed and underpinned and informed by the three principles of peacekeeping that have almost like a trinity status in the law and practice of UN peacekeeping. And there's three principles. One is the consent of the parties, right? And here we see that legally speaking, the UN's only required to get the consent of the territorial state. But operationally speaking, if you want a peacekeeping mission to be successful, you need the consent of all the parties. And this is where the UN usually deploys peacekeepers after there's a ceasefire agreement signed or a peace treaty negotiated, and they go in to monitor the implementation of this peace treaty. And so there has to be a commitment to the political process. And in the absence of that commitment and consent, the UN has acknowledged it risks being drawn into the armed conflict, right? The second principle is impartiality. And impartiality is crucial to maintaining the cooperation and consent of the main parties to the conflict, but it shouldn't be confused with neutrality or inaction. If the UN is required to be impartial in its dealings with the main parties to the conflict, but very much partial in the execution of its mandate. The sole objective of the mission is defined in its mandate, and we'll take a look at what that is, and it is dedicated to the implementation of that mandate. That's its sole purpose for its existence, is to implement that mandate, okay? So the mandate is everything. And then the third one is the non-use of force except in self-defense. And this is like the very fulcrum of the whole equation, in the sense that peacekeeping operations should only use force as a measure of last resort in self-defense. And it should be basically necessarily calibrated, proportionate, and use the least amount of force. This is basically, it should be lawful pursuant to international human rights law. But over the last 30 years, we've seen the progressive development and expansion of Principle 3. It started out as use of personal force and personal self-defense. If your life's being threatened, respond in force to save your life. Then it got expanded to, unit self-defense, which basically means, okay, you can also use force to save the lives of other peacekeepers in your unit, obviously. And then it got expanded again to actually protection of civilians. Of course, we have this idea of civilian protection mandates now. So you can use force now to protect civilians that are under the threat as well. And then it's been expanded once again to defense of the mandate itself. So we've seen this broad expansion of the concept of self-defense, and we're at this point where now it's gone from individual self-defense to the use of force to defend the mandate itself. And we'll kind of look at the implications when we look at some of these mandates. So what is robust keeping? Well, as I've mentioned, this is a reference, legally speaking, to the actual mandate, the content and scope of the mandate that was developed and provided by the UN Security Council. And basically the mandate describes the objectives of the mission, the peacekeeping mission, and it describes all of the tasks that the peacekeepers are allowed to perform or engage in order to achieve those objectives. So mandates contain both hard elements and soft elements. And that's basically based on vague or explicit elements. Sometimes the vague elements are in the objectives, where the hard elements are like the geographical and temporal scope of their area of responsibility. Don't cross this border, don't go over the river, reporting requirements, these types of things. But the UN Security Council has this habit of using creative ambiguity when it's drafting its resolutions, not to tie itself down or to limit itself in any way by its resolutions, okay? For our purposes today, these robust mandates, they dramatically alter the rules on the use of force for peacekeeping forces operating on the ground in what we'll call the robust mandate. And they basically use this expression, all necessary means or all necessary measures to carry out the mandate. Now within Security Council practice, this is a euphemism for the use of force. We see it not only in relation to security peacekeeping, but we see it in relation to peace enforcement. So when they provided the resolution that authorized NATO to intervene militarily in Libya, it said NATO is authorized to use all necessary means to do A, B, and C for 30 days, okay? And so this is the kind of language. It's an uncontested euphemism for the use of force. So what does an actual mandate look like? Well, this is a Security Council resolution that created the mandate in the peacekeeping mandate in the Democratic Republic of the Congo. And we'll look at it. It starts off by saying acting under Chapter 7, which means I'm creating international law for the entire international community, and everything that comes now has a legal basis for the peacekeepers to do everything that they're going to do has now a legal basis. But it has this great thing. It says, without creating precedent or any prejudice to the principles of peacekeeping, decides to create an intervention brigade, which consists of 3 infantry battalions, 1 artillery battalion, and a special forces and reconnaissance company in the headquarters in Goma. And then it gives this new intervention brigade authorization to take all necessary means, and then it starts detailing the tasks it had to do. Protection of civilians, yes. Protection of United Nations facilities, personnel, equipment, yes. But then also, in support of the DRC authorities, carry out targeted offensive operations through the intervention brigade, whether unilaterally or in cooperation with the DRC armed forces, to prevent the expansion of armed groups, to neutralize armed groups, and to disarm them. This is the most robust and explicit mandate that the Security Council has ever given a peacekeeping mission in the world yet. And it's clearly, this is an offensive mandate, right? This is no longer self-defense. We have a legal basis to launch offensive military operations against armed groups. right? This is what it looks like in practice. There's 18,000 personnel on this mission. 12,840 of them are military personnel. They have heavy equipment, they have helicopters, tanks, you know, it's looks very different. And the activities that it's engaged in, obviously, is very different from what we would assume a peacekeeping mission. Now, even though the Security Council said, well, without creating any precedent or without prejudice to those three principles, this intervention brigade has had a profound influence on the development of future peacekeeping missions. We see this in MINUSA, which is the one in Mali, which also is one of the three that we're going to look at that has robust mandates. And when the Security Council was debating this, the government of Mali urged the Security Council to give them an intervention brigade. Like, we want an intervention brigade just like the DRC has. We need it. Look what's happening. And the Security Council couldn't agree. Remember, a Security Council resolution is basically the lowest common denominator of the 5 permanent members, what they could agree on to provide. And so they got a Chapter 7 resolution. It doesn't have an explicit offensive mandate, but look what it does have. Again, use all necessary means, so use force to stabilize key population centers, which basically means to take back cities that are under the control of armed groups, to deter threats and active steps to prevent the return of those armed groups to the city. So take the cities back and hold the cities while you're doing it. Protect civilians, obviously, protect its UN equipment, expand its presence, so outside of the urban areas. Once you have all the urban centers under the control of the peacekeeping force, then expand it into the rural areas. And then it urges all parties to comply with international humanitarian law, which basically acknowledges that it's an armed conflict, but doesn't acknowledge that the UN is a party to that armed conflict. Again, we got 17,500 personnel, over 11,000 which are military personnel. You know, but there's also almost 3,500 civilians, 1,700 police, right? Police officers, staff officers, humanitarian officers, but by far the largest contingent, again, is the military. And the final one is MINUSCA in CAR, and we have the same type of mandate. We don't have an explicit mandate with that intervention brigade, but the government of CAR also asked the Security Council to make it a intervention brigade. And there was a few outlying states that were like, no, we're not making intervention brigades for every country. That's not happening. But they got this Chapter 7 mandate, which created law to do all necessary means, so carry out force, use force to carry out its mandate. But it talks about the rapid extension of state authority, adopt urgent temporary measures to maintain law and order and fight impunity, confiscate and destroy weapons of those who refuse to lay down arms, authorizes French forces to support MINUSCA, because the French forces are already on the ground right now at the request of Mali. And so it augments those forces. So basically, if you look at this from a lawyer perspective and from the lawyer's eyes, I can almost fit anything under these terms and these kind of objectives. The rapid extension of state authority, but through the use of force authorizes almost everything. So the question is, are robust peacekeeping missions compatible with the 3 principles of peacekeeping that have been around since the creation of peacekeeping? And here I should mention that there's some commentators that think that beyond those 3 missions, there's other robust missions, but I'm only focusing on those ones because I think they're clear. So if we look at the consent of the parties, clearly it has the territorial state's consent, but we can't say that those mandates have the consent of all the parties to the conflict. That would make nonsense out of the idea of consent, right? Sometimes there's a ceasefire agreement in Mali, and then, you know, and that would be used to kind of indicate political commitment to the process. But we know that armed groups splinter and then proliferate, or priorities change, and ceasefires don't last long, and peace treaties, we need a whole series of them to bring an armed conflict to the end. So this idea of consent is basically out the window, which risks the UN being drawn in as a party to the conflict. Impartiality, definitely we see these forces partially implementing the mandate, which they're supposed to do. But impartiality in their dealings with the main parties of the conflict, again, out the window, right? M23, the main armed group in the DRC, was, you know, the target of an offensive military operation by an intervention brigade. So it doesn't, there's no type of impartiality. And then the non-use of force is set for in self-defense. So if you have the intervention brigade has an offensive mandate, so obviously that's not a self-defense use of force, it's an offensive use of force. But the other 2 that don't have the offensive mandate still have the ability to use force to defend the mandate, which includes offensive operations in it, like securing cities that are in the hands of armed groups, extending state authority, right? Doing patrols out in the... So we have this where we can use all force to defend the mandate, and the mandate is basically a warfighting mandate. And a lot of people now at the forefront of debate, states, governments, think tanks are like, this has gone too far. These three, robust peacekeeping is incompatible with the object and purpose of those three principles of peacekeeping. And what that means, the question before us then, are these actually peacekeepers or are these parties to the armed conflict? And what's the difference and why does it matter? Well, there's a lot of reasons, but the primary one is if it's peacekeepers, then all of their operations need to be conducted in accordance with international human rights law, including the use of force, which restricts but doesn't categorically prohibit the use of lethal force to protect life. If they're party to an armed conflict, then that means they're bound by and subject to international humanitarian law, which means that they're not considered civilians and their actions will be regulated, their conduct will be regulated through international human rights law, and the lawfulness of conduct of others towards them will also be regulated by international humanitarian law. And it means that basically they won't be considered civilians under humanitarian law. And why does this matter? Because if they're not civilians under international humanitarian law, then attacking them and killing them is no longer a war crime if that death was lawful under international humanitarian law. So if they used a poison weapon or if they used perfidy to kill them, that would still be a war crime. But if their attack and the death of the peacekeeper was in conformity with how IHL lets you kill, then it wouldn't be a war crime. So how do we determine if they are? Well, what's the UN's position? Well, the UN has a lot of positions and it hasn't really formally stated any of them. Okay, in the Brahimi report it said we're not in the business, we don't wage war. And that's pretty obvious because the UN's mandate, the entire reason for its existence is to save future generations from the scourge of war and maintain international peace and security. So obviously it doesn't wage war to make peace. And so instead but it's also come out with specific legal arguments in the sense of the UN can't be a party to an armed conflict because it cannot be a high contracting party to a Geneva Conventions, which is only reserved for states. And that's true, but here this confuses the concept of a high contracting party to a Geneva Convention and the party to an armed conflict. If you had to be a high contracting party to the Geneva Conventions, then rebel groups could never be a party to the armed conflict, making the whole concept of non-international armed conflict defunct. So that doesn't work either. The UN's also said it's incapable of fulfilling its obligations of a party to an armed conflict, and that's why it couldn't be one. And in particular, because the party to an armed conflict is responsible for the conduct of all its armed forces, if there was breaches of international humanitarian law, the UN would be committing war crimes, and would be required to investigate, punish through criminal procedures those responsible. All of this stuff right now is the responsibility of the troop contributing states through what we call SOFA agreements, status of forces agreements between the UN and the state. The UN basically says all of these criminal, if the troops are involved in human rights violations or law of war violations, it's this troop contributing state's responsibility to address those. So that's also a big problem. The problem is that at the same time, all the groups in the DRC, we say they're a party to the armed conflict. So we're saying that the rebel groups in the eastern DRC or in southern Sudan can fulfill the obligations and become a party to an armed conflict, but the UN's incapable of doing it somehow. Again, this argument doesn't really hold any water because all of those armed groups then wouldn't have that same capacity. And if we look at the laws of war that apply from an international towards a non-international, there's a big difference on the content and scope of law. And they're basically relative in non-international armed conflict to the capabilities of armed groups. Peacekeeping missions are operating under the legal authority of Chapter 7, so everything they're doing is lawful, and the moral authority and the political will of the international community, so we're definitely not. You've sent us here to make peace, we're definitely not a party. This is a philosophical argument and a political argument. I should mention that the UN has recognized the abstract applicability of IHL through this bulletin on the respect of fundamental principles of IHLs by peacekeeping forces. But it basically is a document, a soft law document that cherry picks that we won't attack civilians, we won't torture, we won't do all of these different things and we'll respect these. But at the same time makes clear that they're not a party to the armed conflict. They're not liable and they're not subject to this principle of equality of belligerents, right? And so it's the actual applicability of IHL in terms of a party to the conflict has never formally or explicitly been acknowledged by the UN ever. to this day. So there's another approach then. There's an approach that let's look at the mandates, and maybe we should use the mandates to determine whether they are a party to the armed conflict or not. And this mandate argument has both of them in it, both sides of the coin in it. So one position, if the mission operates within the normative and legal bounds of the mandate itself, they shouldn't be considered a party. They haven't overstepped it, so they're not a party. This seems to be the most recent position of the United Nations for a number of reasons, because they acknowledge the applicability of humanitarian law, but then they never acknowledge that they're a party to the conflict. And in these resolutions that create these robust mandates, they actually condemn attacks against peacekeepers as international crimes and war crimes in the same preamble where they're establishing an intervention brigade to launch offensive military operations. So it obviously doesn't view it. They're under the possession that they have civilian status. Second one is like, no. Robust mandates are incompatible with the three principles of peacekeeping, and so we have to find another term for this, because this is not peacekeeping as we've understood it for the last 60 years, and it violates all the principles, so the mandate should be used to determine whether the legal status is. Now, we could talk for an hour about these, but the common thread of the problem between them is that they conflate the jus ad bellum and the jus in bello. They're trying to use legal issues or arguments at the jus ad bellum level to determine the applicability of the jus in bello, or international humanitarian law. And that's just never how the system works, and that just is incompatible with how international humanitarian law works. When the drafters, after World War II, when the drafters of the Geneva Conventions were drafting its material scope, what it would apply to, it said, we're going to abandon this concept of war because it's a nightmare in the sense of it's so political. And states are always debating that, oh, they're not engaged in war. What we're doing is a small operation. It's a policing operation. It's this and this, but it's definitely not a war. And so they replaced the term war with the concept of armed conflict. And they're like, this is independent from the jus ad bellum, and it's a factual, objective determination based on the prevailing facts on the ground. And we have this thing. So we have this idea since 1949. The Geneva Conventions universally ratified, customary international law, use Kogan's, all that. Everyone likes them. No one disagrees with them. All of that. In it, for non-international armed conflict, the concept of a party is not defined, leaving it open to debate. And to be honest, if we look at the last 20 years, every time a new actor emerges on the battlefield of a non-international armed conflict, we have this big debate. Oh, are they capable of becoming a party to the armed conflict? We saw this with terrorist organizations. Al-Qaeda can't be a party to the armed conflict because it's a terrorist organization. We saw this with drug cartels in Mexico or in South America. Well, they can't be a party to the armed conflict because they're economically driven. They don't have this political motive to overthrow the government. We saw this private security contractors in Iraq in 2003, 2004, 2005. They can't be a party to the armed conflict because they're a private company. And today we're having the same debate about UN peacekeepers. In all of those other examples, obviously it was in the affirmative. Of course they can, because we have an objective test called the Tadich test, which emerged from the case law. And basically it's two-part. In order to qualify as a non-state party to a non-international armed conflict, you meet two requirements. One, you have to have a certain level of organization. And two, that level of organizations enables you to engage in armed violence or hostilities of a certain intensities. Okay, and once those two factors have met, you become a party to the armed conflict that's bound by and subject to international humanitarian law. It's called the Tadich test. Within it, the motive is irrelevant. It doesn't matter why the armed group has taken up arms, or if they're fighting for a just cause or an unjust cause, or whether they're terrorists, or whether they're trying to export cocaine around the world. It doesn't matter about the motive. It matters if whether they're factually engaged in hostilities of a certain intensity, and they have a certain level of organization which lets them engage in those hostilities, but also implement and enforce international humanitarian law. There's two approaches under IHL. One is this Tadich test, and used, so you apply that to determine whether the UN peacekeepers are a party to the conflict. The problem with the Tadich test is that it's only used to determine when a situation of armed violence amounts to an armed conflict and triggers the applicability of IHL in the first instance. With these peacekeeping activities, we're seeing the UN enter into a pre-existing armed conflict where IHL is already applying. So we can wipe off the Tadich test. It's inapplicable to this case. And this was acknowledged by the International Committee of the Red Cross, who's the guardians of IHL. And they said, yeah, we're going to have, there's a new test. We need a test because this is a huge problem. We're having these peacekeeping forces and they're fighting alongside government forces, and they're trying to say that they're not subject to IHL and that you can't attack them even though they're operating alongside armed forces in an armed conflict. And so there's these four criteria. For our purposes, It's the second criteria that we want to know is what type of activities do these armed forces have to engage in order for them to qualify as a party to the conflict. And this includes things like fighting alongside, obviously launching offensive operations with the government's forces, that automatically would include it, but planning, coordinating military activities, transporting parties' troops to the front lines or equipment or ammunition, providing air-to-air refueling for fighter jets that are engaged in aerial operations, defending, guarding territorial installations. So they've drawn this distinction between direct and indirect contribution to the hostilities. And so that general indirect would be like the war effort. That would be like equip and train, financial support or technical support to equip and train forces in the field, or the transfer of weapons and munitions to a party in the first instance. So right now we're at this huge debate. This is where the international community is at with should, if, when, and how peacekeepers should be a party to the armed conflict. And I should highlight that Canada's mission in Mali, this was at the forefront of international debate and concern in Canada, because the Judge Advocate General and the legal side of Canada came back and said, look, our troops are doing delivery of munitions, we're doing air-to-air refueling, and it looks like we're going to be drawn into the conflict, which means that Canada will officially be at war and we will be liable to direct attack. And there was this whole debate, the political side of Canada said, no, we're peacekeepers. We're not waging war in Mali. I don't know what you think you're doing, but you're not doing that. And so what happens is we have a rapid conclusion of the Canadian forces in Mali. The legal implications, this is the last thing I wanted to mention. So what are the legal, let's say we say yes, well, what are the legal implications of this? Well, first we have to decide who or what is a party. Is it the UN itself that's a party, like in Geneva, New York, that building is a military objective? Is it the troop contributing countries who always say, no, we don't want to be a party. If the UN goes to war, that doesn't mean Canada goes to war or China's at war. No one wants to be at war. So there's this huge question, or should it be, if we looked at those missions, does it include the entire mission? So the civilian part and the police part and the humanitarian part and the medical part, is all of that a party to the conflict? And the answer to this question has a profound implication on all of the others. So the first consequence is that they're a party to the armed conflict. This principle of equality of belligerent, the law applies to us, the UN peacekeepers, just as it does the rebels, which means that you're no longer civilians and you're no longer immune from direct attack. And this has the reverberating implication that killing you is not a war crime under international humanitarian law, right? They're not civilians, so they're they're not immune from direct attack. This also applies, though, however, to all of the UN, or depending on who the party is, installations, equipment, cars, bases, barracks, all of these things become potentially military objectives because they're a party to the conflict. They're not a neutral arbiter of peace anymore. The UN is also responsible for the conduct then of all of the armed forces, and it's not the troop contributing states anymore. It's actually the UN who is the party to the conflict. But the biggest one that I think receives the least attention is this increased need for distinction. As I mentioned, that golden rule of IHL, distinguish between military objectives and civilian objects and combatants and civilians, is blurred because the risk is that the rebels and the other side, or the adversary, the enemy, whatever you want to call them, begin to see anything with the UN symbol as a legitimate target now. Well, they're a party to the armed conflict, so you're wearing that UN badge on your shoulder, you're a target, right? Oh, this is a UN compound, so it must be a military objective. And we've seen that this would create a huge problem for implementing the principle of distinction, because the whole mission has medical sectors and police and civilian sectors. But now, as I talked about, the UN wants these integrated stabilization missions. All of this falls under the force commander of the entire mission, and it's all physically located in the same space. Now, this fact in and of itself might breach international humanitarian law, which puts a prohibition for parties to an armed conflict to commingle military and civilian objects, right? And so the UN would have to basically dismantle its entire structure that it's been developing for the past 30 years and separate military installations, military personnel from all of the others, the civilian, the medical, the humanitarian, the political, all of the other things that wouldn't qualify. There's also the question of the military uniform, right? There's a prohibition of perfidy in international humanitarian law, which is like wearing or the misuse of an emblem that's protected. The UN emblems and the emblems of the International Committee of the Red Cross have special protection under international law, right? But if they're not civilians, then maybe they shouldn't be wearing those blue helmets and those blue badges to say they're part of the UN, because again, rebels are going to think everyone with that blue badge on your arm or on the helmet is then a legitimate military objective, which is definitely not the case. And we've seen in practice now in Mali, humanitarian organizations and NGOs don't want the military escort anymore. Because every time that the military escort goes out, they get attacked, right? Because it's a military objective. So they're like, you don't want to stand by a military objective if you're not part of the armed forces. You don't want them taking you anywhere. You don't want to get into a military objective. You don't want to stand by one. It can be lawfully and legitimately attacked, destroyed, and you could be killed, all within the confines of the law. So the implications of this legally are profound. Practically, they're profound. But then there's the political implications. Because for states to contribute troops, the UN always needs troops, right? It always needs peacekeepers. But no, we're going to have it, if they're like, we're sending you to war, then we're going to have this huge problem of, well, states aren't willing to go to war. We want to wage peace. So find someone else to wage the war. We'll do the peace ones because it makes us look good rather than waging the war. So we're at that question. We return, are they peacekeepers or parties to the armed conflict? And that's it. I'll leave it there. I hope that I struck a balance between content and scope so it wasn't too technical to be over everyone's head or not too boring in the sense of too general. But yeah, so this is one of the big issues up for debate, so I'm happy to answer any questions at this time.
Thank you, Nathan, and I'm just on the screen there as well. I'm Jason Brennan. I'll try and moderate the Q&A for the next 15 or 20 minutes. And I do acknowledge there's about 30 people in the room, both in the room and online, and I just look at the roster of names, and they come from security studies, human rights, political science. We know we have philosophy students here, peace and conflict studies, and we even have peacekeepers in the room who might look at their past service differently through this new lens. So I'm going to do my best to moderate questions on the topic, and so I invite people who are online to either raise their hands or type their question into the Q&A box, and I open the floor in the room as well to questions. And if someone in the room would like to start us off, then I'll be watching online. So Taufik, would you like to begin for us?
Yeah. Thank you for the presentation. What I understood, if I'm clear, is about the fear of the proliferation of the robust missions, of robust mandates, because it's mostly happened, I think, after Bosnia, when especially General Sir Robert Smith in one of his books also, because the paradigm of war now is shifted. Now it's no more industrial state wars, war among us people, what he mentioned. Because as you said, there's no clear uniform, there's no clear front lines between armies. So it's war among us people, you don't have. But here, I look at it, I do want to hear your comments about, is UN trying to be the face of the, let's say, superpower states in their war against non-state actors? And in that sense, because they're more providing troops, resources to those robust missions. And in the back, as you said, in case of Canada, say we are peacekeepers. We don't fight anyone in Mali, but it's a backdoor that, let's say, the Western countries, they are trying to fuel the war or fight against non-state actors through those robust missions. Thank you.
Yeah, it's a great question, and it's definitely not just a legal one. There's like politics in there, and philosophy in there, and morals in there. I think two things that I could bring. First is that if these types of robust missions, if we look at it's not new. The mandate, explicit mandates are new, but if we look at the first mission in the DRC, somewhat paradoxically, the UN was basically fighting a war in the DRC, right? In 1966. So if we look at that first mission, it didn't have a mandate to do it, but that's what its soldiers were doing on the ground. So, and since then, you've mentioned Bosnia, there's other missions that have had very much this. This is the first time we're seeing these explicit mandates. When the intervention brigade intervened into the DRC the M23, the main rebel group in the Eastern DRC, came out immediately and said, the intervention brigade is a party of the armed conflict, and now we will be directing operations against the UN in Eastern Congo and they basically applied IHL. The UN intervention brigade basically defeated that armed group within the first year almost, and it was successful. Well, there's still war in the Eastern Democratic Republic of Congo, and the remnants of M23 are now different armed groups. But for all intents and purposes, it defeated M23. So I guess when a government is so struggling, what happened in the past before they could get the UN to do it is we had executive outcomes, which was a private military corporation that operated when it was intervened into the Liberian Civil War way back in the day, and basically got the Liberian government, I think it was Liberia, executive outcomes, paid it off in diamonds and oil, and it basically won the war for a private corporation made up of mercenaries from South Africa, won the war for the government, right? So I'm wondering if we're gonna allow governments to fight rebels and fight armed groups, do we want them going to private corporations to do this? And if so, would there be more or less accountability in terms of human rights and humanitarian law? Or should we enable the UN to create a robust peacekeeping mission with a mandate to eliminate that? Now, the question I have is, well, maybe the government's not legitimate and the people are fighting for it. So there's one type of war where I think the Security Council couldn't authorize that, and that's a war of national liberation, where the people are fighting for their right to self-determination, which is a jus cogens under human rights law, and it's enshrined in humanitarian law, and it makes a non-international armed conflict between the peoples that have a right to self-determination automatically international, which gives them combatant status and prisoner of war status and all these different things. So I think there is some restrictions on the legislative competence of the UN to do this, but I think if you're really interested in the question is you look at the meeting minutes of the Security Council when they're debating CAR and Mali resolutions, certain governments were like, no way that we're doing this, we're not gonna do this. Other governments were pushing for, yeah, this government really, really wants an intervention brigade. Should we, I guess now it's a moral question or a political question that I would put back. Should we do it or not? I don't know. I guess if we don't do it at the UN or if the UN doesn't do it, there'll be a private security company that will jump in like that and make millions off of doing it. So who would you rather do it, a private corporation or the United Nations, I guess? Someone's going to do it, or the government falls, and maybe the government should fall. I don't know. I don't know. I'm just speaking generally.
I wonder if you could talk maybe about the sort of genealogy of this movement or the history of this movement. I'm thinking about the 2001 authorization for the use of military force, which has a lot of the similar language, like like in terms of scope, like all necessary force comes out of that, and then also the rhetoric around unarmed enemy combatants, which also has played into terms of what you were talking about. I wonder if those dialogues have informed it. Those sort of predate the modern movement, but.
So you're talking about the AUMF authorization to use military force, the US legislation, that's like, this is the piece of legal architecture of the global war on terror. Yeah, no, this predates that. The global war on terror is completely separate. That piece of legislation is a national piece of legislation that conflicts with a lot of international law, so it wouldn't be in there. The idea of an unlawful combatant in international humanitarian law, there's no such thing as a legal category of unlawful combatant. We have combatants, which have a right to participate in hostilities. We have civilians, which are right to protected. And we have civilians who directly participate in hostilities without the legal right to do it. So in an international armed conflict, you would have civilians who take up arms and participate in hostilities. And when they do that, there's this wording of unless and for such time. Civilians in the law of armed conflict are protected from direct attack unless and for such time as they take a direct part in hostilities. And so they lose their immunity from direct attack and can be killed. But all of those conflicts now that we've seen since the Supreme Court in Hamdan versus Runfield, the Supreme Court of the United States said no, it's a non-international armed conflict. Because the United States tried to make an argument that human rights law doesn't apply, international humanitarian law doesn't apply because it's not an international or non-international armed conflict, and the US Constitution doesn't go to the people in Guantanamo Bay, so it's like a legal black hole. After 20 years of the global war on terror, we've kind of reduced all of those arguments and have been vindicated in the Supreme Court. So basically rebels in a non-international armed conflict, international humanitarian law doesn't authorize them to take up arms, but it doesn't prohibit them to do it. The problem is that when rebels take up arms in a non-international armed conflict, even if they respect all the laws of war, every single thing, they're still subject to the full force of national territory. That's why there's no combatant rights for rebels in non-international armed conflict, because the government didn't want to give them a legal right to kill their soldiers and to blow up their installations and all these things. And for humanitarians, the problem is that it's hard to induce respect for international humanitarian law. I've spoken to arms bearers, they're like, why would I respect IHL? Because if I get captured by the state, I will be executed for treason anyways under national law, so it doesn't really matter. if I respect IHL or don't. There's no incentive for me to do it because I'll go to prison forever or I'll be killed for it. Because those states that retain the death penalty retain it for sedition, treason, these types of things, right? So there's political reasons, I would say. Like if you want political legitimacy at the international level, you come out and say we respect international humanitarian law and we think A, B, and C is a legitimate military objective and we won't attack civilians, and then you gain political legitimacy for your armed struggle. But that's a separate from the legal aspect. I don't know if I answered your question, but they're two different things for sure.
Yeah, just the it was more to me the language that struck me. You said some things that really keyed into me, and the limitations one, like of the one paragraph in the middle of the UMF, like the all necessary.
All necessary means.
You essentially quoted that word for word in a lot of different ways, and then the text you highlighted was their sort of like interpretation of that all necessary and legal means. And
And that's used throughout the UN at the force. So when they, as I mentioned, when they intervened in Libya, they were authorized to use all necessary means to protect Libyans under the threat of attack from the members of the Gaddafi armed forces, and do A, B, and C, all necessary means. Yeah, there's entire articles written on it. If you look from the legal perspective of what all necessary means, the limits of it legally speaking.
Was there a similar concern in 1994 about becoming a party to the armed conflict in the decision to pull out Lieutenant General Romeo Dallaire from Rwanda in the Rwandan genocide?
Okay, interesting one, because they didn't have the mandate to use force. So basically, Dallaire's arms in that mandate, where we have to contextualize 94 Rwanda with one, just getting out of the Balkans, and two, the operation in Somalia that's going on, the peacekeeping operation that's going disastrous, right? So we have two interventions going on that have utterly failed so far, and now this new situation's on, and Romeo Dallaire had a Chapter 6 mandate, which didn't authorize any force of anyone but self-defense. And so he requested a Chapter 7 mandate and all of those different things, but the international community was so reluctant at the time, and if you go through, you can read if you really want to know because those Security Council resolutions are the product of political compromise, they're the lowest common denominator, you can go through the meeting minutes and see the discussions unfold on what was going on. So from an academic point of view, it's very interesting to gain insight to the discussions that went, but basically Romeo Dallaire had a small mission and there was no political will to increase that mission or to provide an offensive mandate in the sense of what we're seeing today, because of the odd things that were going on in Somalia at the time, or just finished in Somalia and in the former Yugoslavia. And then led to this huge disaster, right, obviously, of the Rwandan genocide. And Romeo Dallaire basically watching it unfold while the international community is deadlocked in the Security Council.
Thanks very much. I really appreciated the presentation. I was just curious if you would include in the sort of category of robust peacekeeping and some of the challenges when for a while there, especially in the decade of sanctions, peacekeeping missions on the ground that did not have a Chapter 7 authority would be asked to enforce UN sanctions, which are under Chapter 7.
Yeah, that's a great question. And there's no real satisfactory answer. I think, that's one of the huge legal debates. And I think that's why we're seeing that robust mandates now always coming with a Chapter 7 authority to ensure that they have a legal basis. But I guess it would depend on the type of actions they were using to enforce the sanctions, which definitely have to come from Chapter 7 authority. And I know in political science that there's this theory in a Chapter 6.5. So it's not a Chapter 6 and it's not a Chapter 7. We don't have a Chapter 6.5 in law. It's either a Chapter 6 operation or it's a Chapter 7 operation. But I can understand the appeal of this Chapter 6.5 kind of analysis to make normative arguments of like 1 foot in Chapter 6, 1 foot in Chapter 7. Should I use force, not use force? But yeah, I don't know. I guess it would depend on the type of operations or activities that were used to enforce the sanctions. But I guess a question I would also have is, should they be enforcing sanctions? And if you're talking like arms embargoes, like confiscation of weapons caches at the port of a country, is that what you mean by enforcing sanctions, arms embargoes?
Yeah, it's those sorts of embargoes, and especially when the UN was enamored with sanctioning lootable resources such as diamonds and fish and charcoal and things like that. And the thinking was, well, we have peacekeepers on the ground, they could perhaps help to enforce these sanctions and sort of seize them on the ground. But you're then asking peacekeepers that are depending on host approval to be there, potentially enforcing rules that may be working against the government of the day. So just sort of that legal quagmire.
Yeah, it's definitely a legal quagmire, I would say. I think it's indicative of one of the many things that highlight the problems and prospects of current peacekeeping missions. But yeah, I think now most, well, this one's an interesting one because if there was no, there's a question of if the peacekeeping mission started taking operations against the state's forces, there's always a provision in the mandates. If you're ever interested, look at the mandates of the peacekeeping missions, because this might give a rise to an international armed conflict, right? If the UN starts fighting the territorial state's either gonna withdraw the consent, which means that the peacekeeping forces will have to leave. This happened, or almost happened in South Sudan, where they had to use the Security Council backdoor discussions to force almost the consent of Sudan and South Sudan to have a peacekeeping force in Abyei. But yeah, I think that it becomes hugely problematic because if consent is withdrawn and the peacekeepers stay and engage in operations against that, that would create an international armed conflict potentially between the United Nations and a UN member state, which would be hugely problematic in international law, I think.
We probably have time for one more question.
We have seen, peacekeeping operations throughout its own history, kind of developing from such as, classic missions. We used to be just doing a buffer zone between two state forces.
Yeah.
And it was kind of an easy way to just stay there between conflicting parties. And actually, especially after the end of the Cold War, all the dynamics of the conflict has changed dramatically. I would say 180 degrees.
Mm.
But it seems that all these rules, not only legally speaking, but politically speaking, were done, in a different time, from different purposes, for interstate warfare, for actually easier tasks for the military. We have to remember that the peacekeepers nowadays are used not only to do kind of kinetic activities, pure military activities, but they are involved even in peacemaking, peace building, peace enforcement, all throughout the spectrum of this, concept that you showed before.
Yeah.
So, and it's actually a complex situation for the military in the end of the day. And it seems that the UN rely basically on, this kind of diplomatic immunity just to try to patch all the wrongdoings. Mm-hmm. But what is the ending point of this? Can you see because it seems that the UN is not capable to adapt to the new situations. We have the Brahimi report, making a lot of recommendations that never got implemented 100%. Then we have the General Dos Santos report advocating for this robust approach, but his recommendations have not been applied yet. And then we are still moving, and it seems that the UN is kind of a slow motion organization, incapable of adapting itself to the new scenarios.
Yeah, I think that's a big question with lots of complex moving parts. But I think one thing that I would highlight in response to the question, I don't have an answer to that, other than I think one part is that the rules of international humanitarian law are ancient. like they go back like much older than human rights law, right? We're talking 1864 is the first Geneva Convention, right? So like hundreds. I think a lot of those rules are fundamentally still applicable and valid and necessary and, you know, and relevant today. There's one thing is that, you know, that the United Nations was envisioned to have a standing army under Article 43. But then the Cold War break out and that whole Article 43 of UN forces didn't happen. So right now, some people are saying like, and that's been dead. Article 43 standing UN army has been dead forever, right? They're supposed to have a military council attached to the Security Council and we're supposed to have a global army. Now some people are like, whoa, maybe it's time if we're gonna start is to separate peacekeeping from a UN army. And maybe we should look at a UN standing army under the command and control that only fights wars on behalf of the UN. But the problem here is I don't know if the world needs a global army of UN peacekeepers, or maybe it's better than having it NATO or EU building an army to counter NATO and then the UN building an army to counter NATO, or how would it work? It would have to be under the command and control of one of the five Security Council members, which means it would be inherently political. Would it be more neutral than a state? I don't know. But one of the proposals is we need to separate war fighting from peacekeeping because now peacekeepers are doing them both. And it's not working, it's creating problems on the ground, and it's legally incompatible with all the other laws that are out there. So let's just acknowledge what we're doing. A rose is a rose is a rose, right? We saw those operations and those mandates. Is that what we envisioned peacekeeping to be? No, but maybe it's still necessary. From a political perspective, I don't know these questions. I don't have like specific opinions on them, on all of these political questions. But I agree that how it is right now, it's at a turning point. We have to go either this way, that way, or this way, because we can't go on this ad hoc basis of you get an intervention brigade, you get the law to do anything else, you get to extend state authority, because then it's just like a, you know, there's no rhyme or reason to how it goes. And maybe that's the better way. I don't know.
Excellent. Thank you, Dr. Derejko, for taking a couple minutes over to answer some questions. And I'm sorry we didn't get to all the questions. There were others, but thank you very much for your time today. Thank you, everyone, for attending. And on behalf of the Mauro Institute for Peace and Justice, look forward to seeing you again at a future Brown Bag lecture. Thank you.
Thank you for inviting me. Thank you.